Good evening, everyone. Yeah, so we would like to discuss Ghana legal system tonight. So, of course, there are certain basic things, as I said, we don't have to take for granted because we don't have any certainty regarding exactly what is going to be examined in terms of the topics. So we are told to be, for one, is to be forearmed. So once we know that these are the 6 examinable subjects, we just have to be on top of all the topics which are out there. So with respect to Ghana legal system, one thing I would like us to discuss probably before we continue with what I propose to do with you, that is how to distinguish between a crime and a civil wrong. I would like us to discuss this foundational issue. Ghana legal system belongs to the common law tradition discussed, right? So assuming you have a very simple question like that the Ghana legal system belongs to the common law tradition, discuss or comment on this statement. So we have to remember that we have what we call a legal system as opposed to legal tradition. So we need to understand what the legal system is and then understand what the legal tradition is. And then having done that, we need to states that there are a couple of legal traditions out there, but then as the question has actually indicated, that Ghana belongs to the common law tradition. So now we have a burden to prove or to demonstrate whether the assertion that Ghana belongs to common law tradition is true or not. So that is what is actually inviting us to do. So without wasting time, we have to remember that when you talk about a legal system simply refers to the set of arrangements, right? Of course, Rosa Kwanzaa's book is there, my book is there, and a lot of other books. So I am going about it on assumption that you have actually learned these things already. So a legal system refers to arrangement or assemblage of the rules, the institutions, the personnel, the procedures for making law, enforcing law, and applying law in a particular jurisdiction or society. So the totality of the body of laws, the totality of the institutions involved in the making, the enforcement or the application of the law, the personnel involved. That is what gives you a legal system. So we are talking about where we get the laws from a particular jurisdiction, the sources. We are talking about how the laws, of course, where we get the laws from is very much linked to how the laws are made themselves. We are also talking about the procedures for actually applying or enforcing the law. We are talking about institutions which are there for enforcement of the law, the courts. We are talking about the law enforcement, the police, the prisons, and all that. They are all related towards the enforcement of the law. And again, we are also talking about the personnel, those who make these institutions possible. The laws cannot work by themselves. You need human beings to enforce them. You need human beings to interpret. You need a human being to make a determination as whether the law has been violated in a particular situation or has not been violated. So somebody will have to argue that the law has been violated or has not been violated. And another person will have to make authoritative pronouncement, authoritative determination that it is true the law has been violated, or it is not true that the law has been violated. So there are personnel, human beings involved in all this. You have lawyers, you have judges, and all that. So all these form part of the legal system. And legal tradition, on the other hand, refers to historically conditioned attitudes or mindsets, right, within a society regarding the nature of law, the role of law, the proper organization of a legal system, and how law is made, how law is improved, law is reformed, and all that. So over a period of time, how society has come to understood these matters, or the value systems and the convictions which society has built around these matters, is what we would term as the legal tradition. And that is why we often add the historical bit, that historical condition, meaning that legal tradition is not something which just happen just out there. It is an attitude, or it is a mindset within society, a conviction, right, towards law, which has developed over a long period of time. And for that matter, if you look at the world, we have major traditions. We have the common law tradition, which we'll be saying a few more words about, because that is what the question is asking us to do. We have the civil law tradition. We have the Islamic law or Muhammadan law tradition. We have the socialist tradition. And to some extent, the African law tradition, if there is one. Good. So these are the key, or the principal legal traditions in the world. So we just say a word or two about each of them, and then we come to concentrate on the common law tradition. So as far as the civil law tradition is concerned, civil law tradition, also known as the continental law tradition, actually goes back to the attitude of Roman law, which is essentially the idea that law must be codified. You must have a systematic statement of law on defined thematic areas of society. So that if you take something like family, right, you have like a code, everything related to family, marriage, children, everything. You should be able to get like a code, one big document, which has stated what the legal responses should be as far as the various questions that may arise in the area of family is concerned. You take other things, maybe corporations, institutions, you take, so various areas, they have a well logically arranged systematic statement of the law. For that matter, code, right? Codes are very important in that tradition. And those who research, teach, and comment upon the law, that is a legal scholars, or what we call like the jurists, they are more important in influencing the understanding of the law, so that if a judge is confronted with a case and he has to apply maybe a particular area of the law, and there is some ambiguity or there's a lack of clarity in terms of what is exactly required, all that the judge will do, among other things, is to find out some scholarly commentaries which have been written on that particular aspect of the code. So here you see that the universities are more influential in shaping the law than just previous decisions of the court. So that is one thing we should keep in mind. And that is the main thing about, if you like, the civil law tradition. And then in terms of adjudication, right? In terms of the mode of deciding disputes to, in the civil law tradition, they use what we call like the they use what we call the inquisitorial, right? Inquisitorial approach. Inquisitorial simply means that the adjudicator, that is the judge, he has the responsibility to actively inquire into the various allegations constituting the case before him or her. And that will mean that he will be doing more interrogations and all that. And it's not just for the parties to, that you have brought someone to court, so you have like the burden to prove whatever that you are saying. No, it's not necessarily the case in the civil law tradition. So the approach is more inquisitorial. That is from the word inquisition, like inquiring, as it were. Yeah, so these are some of the basic things that we should remember about the civil law tradition. And of course, for Islamic law tradition, you know that Islam is not only understood as just a religion or a way of praying or relating to Almighty God, but they also think that it's also a way of life, right? And the Prophet Muhammad, may peace of Allah be upon him, has actually indicated, how Muslims should live their life. And that is why, in some places, they would like to establish what we call the Islamic law states and have the Sharia and all that. And there, those who make statements regarding the position of the law are scholars who are trained in the Quran, the Islamic scholars, the imams, and all that. Yeah, so that is how it is. And of course, the main reference, the Holy Quran, the Hadiths, that is the acts of the Prophet, are very much important. And also the various interpretations which the Islamic scholars have given to aspects of the Quran and then the Hadiths over a period are all important. And of course, it has its very unique system of rewarding good behavior and punishing wrong behavior, as you know. Good. Then we also have the socialist tradition. The socialist tradition, if you remember your jurisprudence or philosophy of law, derive its root to a large extent from Marxist jurisprudence, as it were. Of course, the Karl Marx project is more or less a failed project in the sense that it is difficult to get any particular country, on our planet, in the face, in this world where you can comfortably say that that Moses' approach and understanding of law is implemented fully to the letter. There are some attempts to achieve that, but no perfection has been attained in that regard. So let us keep that in mind. And of course, over there, the main idea is about centralization of almost everything, and that the state is so you don't have a lot of emphasis for the rights of the individual and so on. So it is a state which is supposed to shepherd the welfare and then the well-being of, if you like, the citizens and all that. And so the resources and everything controlled by the states. And then when law is being interpreted, law is being made and all that, it should be done in such a way that it will advance the interests of the state, because in the well-being of the state lies the well-being of the individuals. So unlike other tradition like the common law tradition, where an individual can use the resources of the law to assert a position against even the state, and then the court will be excited to lend support what the individual is doing, so long as the law enables him or her to make that claim against the state, as it were. And of course, you remember the collapse of what we call the fiat, the royal fiat. In the past, in Britain, if you wanted to sue the states because of the monarchical arrangement and all that, you needed approval called fiat, that you are given permission that you can bring a case against the state. And that is the foundation of what we call a State Proceedings Act, right, which we have in our country at 555, which of course we have explicitly stated that there's no need for anybody to obtain fiat of the state or the Attorney General before he or she can sue the state. All that is required is that you must give notice. And I think under the State Proceedings Act of Act 555, you are supposed to give a mandatory 30 days notice before you can commence a suit against the Republic or against the Attorney General and so on. Yeah, so that is that. And then, of course, I also mentioned the Africa tradition. Of course, Africa tradition, just the idea that before the advent of the colonialists, the imperialists, the advent of the West into Africa through colonialism and all that, Africans had their own systems. They had their own legal arrangements. They had their own governance system. And when it comes to disputes, Africans also had their own approach and so on. And typically, in the area of dispute, for example, within African law tradition, the emphasis is more on reconciliation rather than just strictly the winner takes all, which is typical of the adversarial system in, let's say, the common law tradition, which we'll be talking about in a minute. So therefore, where disputes are being contested and settled and all that, the arbiter or the adjudicator, the chief or whoever the elders are, the focus is to try and achieve amicable resolution, to achieve reconciliation. So that is the main orientation as far as dispute settlement was concerned within the African tradition. And of course, in terms of law, because in the African tradition too, we have like the chiefs or the king. So he is the source of the law, so to speak. And so he will decree new laws and so on. Or he will be very instrumental in trying to let society know that maybe this particular custom or this particular practice, it has evolved further with some refinement. So it's no longer this way or this is the way. And that is why you look at even our constitution. Our constitution recognizes this relative from our African law tradition, that if we take even our customary practices and all that, there is some dynamism. They evolve. They are not fixed. And of course, it is the traditional leaders who are actively involved in trying to help society to appreciate various refinements or reforms which have occurred or which are occurring in certain customary practices and so on and so forth. Yeah, so this is just an overview, just to give you a sense of the legal traditions out there. But then let's come back to the common law tradition. And for that matter, in what respects or in what ways can we say meaningfully that Ghana is a common law tradition? So first and foremost, we have to understand and remember what the common law tradition is. First, we are talking about the attitude towards law and lawmaking, law application, which developed many years ago, going back to the 11th century, following the normal conquest of the present day England and Wales. And the system of law which evolved there, which has been evolving for many years and have also been exported through colonial arrangements. So what are some of the key features or key characteristics of the common law tradition? So first, we do not have codification. So the law is not codified. That is to say that unlike the civil law counterpart, where you have systematic arrangement, the statement of the law on various thematic areas in society, is not necessarily the same in the common law tradition. And another point to also note is that the common law is based mainly on judge-made law, as well as scattered statutes. So we are not saying that we don't have statutes or we don't have acts of parliament in the common law tradition. No, that is not the point. All that we're saying is that the law within the common law tradition is based originally and authoritatively on case law, judge-made law, stare decisis, judicial precedent. That is the main point to note. And that is why in the common law tradition, Parliament will enact a law anyway, but it is not until the court has applied that law to concrete situation to concrete factual scenario before society will be very much convinced about the true legal position. And because of that, when it comes to also the interpretation of even the law, the principles, the approaches, and then the presumptions which have developed regarding interpretation of law are by and large influenced by the underlying common law tradition. And that is why you may have a clear statutory position there. And the judge will interpret and say that the lawmaker is presumed to know the state of the common law, is presumed to know the state of the law. And that will influence how the court is going to interpret or construe a particular statutory provision. So let's keep that in mind. Of course, the question someone may ask that, yes, you've said that the common law is based upon judge-made law or precedent. What is it? Just the idea we know. Maybe another time we'll talk about precedent on this one as a topic. That's where cases have been decided, and in future you get similar cases in terms of the underlying facts being materially the same as the ones which were previously decided. You don't have to reinvent the wheel. You have to apply the decisions or the solutions which were propounded in the old cases. So you stand by the past decision. You stand by settled matters as it were. So that is the basic idea about the common law. And you remember how law reporting, right, also played a very important role in the development of the common law, because if cases are decided and then they are not reported, if you're a judge sitting in another location, how will you know that this particular matter before you, a similar one has come before a court, which is of a higher status or higher jurisdiction than your court? And for that matter, within the spirit of judicial precedent, you are supposed to apply that. Yeah, so that is another characteristic or feature of the common law tradition. The other feature is what you call trial by peers, the jury trial, which used to be quite common in the past. Although in modern times, the jury trial has been restricted to only limited criminal cases, especially a very serious one. That is where you have actually reduced the jury trial to. But previously, the jury trial was not only in respect of criminal cases, it was in respect of every type of case, as it were. And that is why, if you remember some of your contract cases, if you look at in the case of Hadley and Basendel, right? You look at the case of Smith and Hughes and all those cases, you will notice that those were civil cases, but you can see that there was a jury trial. So if you look at the directions which was given to the jury and all that, good. So the trial by peers or the jury trial was the idea that if someone had a case, you needed to get ordinary people within society to come and sit down and bring their perspective, their point of view to bear regarding on what is at stake. So therefore, based upon the way they see things in everyday life, would they say that having regard to the facts which have been established by the various evidence, would they say that the person did what he or she is being accused of or not? So if they say yes, he did it, then the court will just have to take that as the decision in the case, because they are the tribunal of facts. They are bringing their ordinary and everyday experiences to bear on the case, and not necessarily as experts of the law, as it were. So that is another feature of the common law tradition. And of course, all these features I am talking about, you appreciate that they are at work, or they are actually part of Ghana legal system, all the things that I have said. So let us keep that in mind. And again, unlike the civil law tradition, in terms of influencing what the legal position of the law is, it is judges. It is judges by their various statements in terms of what we call like the dicta, or if there are many, or dictum, which will actually shape the law. And of course, as we learn judicial precedent, you will come to notice that we have what we call the binding aspect of every decision, what we call the ratio decidendi. And then we have the non-binding aspect, what we call the obiter dictum or the obiter dicta, if there are many. Now, yes, the obiter dictum or obiter dicta is not binding. However, depending upon the respect which the particular judge carries, and also depending upon how well the judge actually reasoned, or the pronouncement that he made, which were obiter dicta, in the sense that they were not required for resolution of the issues in controversy or disputes. Nevertheless, in future cases where there is no precedent and all that, future courts may find a lot of assistance in the obiter dicta, which was expressed. So here you see how judges, rather than just academic commentators, who are shaping the law. Now, in the civil law tradition, for example, it is not, as I said, necessarily the judges read opinions that shape the law, but what legal academics or commentators have written about the law. So let us keep that in mind. So therefore, having gone through these features of the common law, of course, we cannot also finish the story without adding that another unique feature of the common law is that the common law, in the course of its later evolution, actually develop a unique sense of justice, that in every type of situation, the law must do something for the aggrieved party, regardless of any technicalities, regardless of any formalities. There should be no grievance which should go without the law intervening to provide some remedy. So I'm talking about development of equity, which came to ameliorate the strictness or the harshness or the rigor of technicalities or formalities, which were actually associated with the original version of the common law, as it were. So let us keep that in mind. Yeah, of course, we know that historically, post the born of 1844, and then later on, the enactment of the Supreme Court Ordinance of 1876, the common law was effectively outlawed in Ghana. And ever since then, our legal system has been developing along the trajectory of the common law. And of course, you go into the, let's say, the Supreme Court Ordinance of 1876, and then you have like the sources of law which are applicable before our courts, and the common law, the rules of equity and all that are stated over there. So that also provides a very important evidence, quite apart from just the political, interference of the colonialists in our pre-existing governance system, but more importantly, the Supreme Court Ordinance of 1876 actually provides the foundation for the outdooring of the common law tradition in our country. So let's keep that in mind. Okay, so that was just something like a teaser. Let us come to the main thing I wanted us to discuss today, but I noticed it's 9:49, and I need about 30 minutes to be able to discuss that. So what it means is that we will not be able to do what I wanted us to do today. So we will draw the curtain down. But before that, I will take any questions you may have in relation to the brief discussion that we have done. So if you have anything to say, just raise up your hand and then we'll allow you to say it. Thank you. Okay, I haven't seen any hand up. So have a very good night, and I will meet again.